I think we'll get started now then. I'll just so we're going to go live on YouTube, and we've got the recording going too. So good morning, everybody, and thank you very much for on behalf of the Spanish Chamber in the UK. Thank you very much for joining us for this morning's online panel discussion event. We're very pleased to be holding the session with our member Cripps Pemberton Greenish, which is one of the country's leading legal practices serving corporate, real estate and private clients. We're joined by Rona Derbyshire, who leads the employment team at the firm, who's going to begin the session by discussing the return of employees to work and the latest government guidance for this. Adam Moseki, a senior associate in the real estate team at Cripps, will then be discussing some of the issues that could test the landlord and tenant relationship as we all transition into the new normal way of office working. This will then be followed by a Q&A with both the speakers, which will be moderated by Salim Somji, who is a partner in the M&A team at Cripps. Please do write into us with any questions that you have. You can do this using the Q&A tool you can see at the bottom of the screen, or also the chat feature there. Any questions or comments you have, please just write them in at any time, and we'll have time to answer all of your questions at the end. But yeah, thank you very much. And I'm now going to hand over to Rona.
Thanks, Hannah. Thank you. So yeah, it's a real pleasure to be working with the Spanish Chamber during what has undoubtedly been a really challenging time for many of you, I'm sure. Who'd even heard of furlough leave a few months ago? And I think I've probably read more government guidance in the last 3 months than I have over the last 12 months in total. So there really has been a lot for businesses to get their heads around in such a short period of time. So for the next 25 minutes or so, Hannah says, I'm going to be talking about how you manage a safe return to work for your staff. And I'm going to highlight some potential pitfalls from an employment law perspective. And I'm then going to end with some top tips for you to take away with you today from the seminar. So what's the latest position? Well, the government, as you will have known, has eased lockdown further by allowing all non-essential retail to open as of Monday. And provided the 5 tests set out by the government are still met by businesses and they comply with the COVID-19 secure guidelines. The government has released 8 separate guides on working safely during coronavirus, and these cover a range of different workplaces. I'm sure your leaders and your HR and your ops teams have been consulting with the government guidance relevant to your type of workplace and your location in the UK. But in essence, the main points of those guidance are that firstly, you need to be carrying out a risk assessment, as well as looking at each specific type of workplace within the business. The risk assessments also need to look at different types of workers. So for example, you need to cover off vulnerable workers, and for those whom you may need to take extra health and safety measures. You must take all reasonably practicable steps to minimise any risks, and that's not the same as having to eliminate the risks altogether. And the government recognise that that's going to be unachievable in most cases, I'd imagine. To clarify what you need to do, you should refer to your relevant sector-specific guidance contained in the government guidance on working safely during coronavirus. And it's important to note that the guidance isn't law. Nonetheless, it should be taken as the minimum that you need to do in order to be compliant with the law. It's possible that you may need to do more than the guidance, and therefore you should really view the guidance as a bit of a framework for you to work around. And so the guidance needs to be read in conjunction with other health and safety laws and regulations, and also in conjunction with any other guidance produced specifically for your sector by industry bodies. So the guidance recommends that you publish your COVID-19 risk assessment on your website, and that's the recommendation, but certainly for all employers with over 50 workers, then you will be expected to be publishing that. And you also need to do a risk assessment, even if you're not reopening the business, because everybody's able to work from home. Obviously, it will need to then concentrate on your home working risks. And then it can be updated after consultation in due course to reflect your plans for reopening as and when that happens. And certainly it's really important that you should be making your staff aware of your assessment and the obligations on them. Then you need to develop your hand washing and hygiene procedures. So you need to introduce, which I'm sure lots of you have done already, but hand sanitizer stations, enhance more regular cleaning of the workplace. The board advice remains and continues to remain that anyone who can work from home should continue to do so, and offices are likely to remain in the short term. Employers certainly shouldn't feel pressured into reopening until they are sure that they can do safely. And certainly lots of my office-based clients are, not expecting to open their offices until about September time. And even some of the larger clients, and particularly those in London, have indicated to their staff already that they're not expecting their offices to be open actually until next year, sorry. You then need to think about putting in place social distancing measures like we've seen in the supermarkets and that work quite well. So the one-way systems, using tape and different signage. And if you can't maintain a 2-metre distance, then you need to reduce the risks as far as you possibly can. So you might need to implement screening and avoid doing hot desking, staggering start times and closing communal areas and that sort of thing. They are reviewing the 2-metre rule guidance on the 4th of July, so it's entirely possible that at that point it might be reduced down to 1.5 metres or possibly even 1 metre. So I suppose I would be reluctant to invest perhaps a lot of money and time and effort at this point. If you're not going to be opening up immediately to comply with the 2-metre, you might be worth waiting a little bit of time and seeing what the revised guidance says before spending, as I say, money on introducing measures into your workplace. It's also really important to understand the difference between PPE, so personal protective equipment, and face coverings, and decide what measures are necessary for your workplace. So it's actually in practice unlikely that any PPE will be required for any offices, but there are circumstances where the guidance suggests that wearing a face covering may be marginally beneficial as a precautionary measure. So these face coverings can be made at home, and employers should absolutely support employees in using face coverings safely if they choose to wear one. I think a practical consideration for employers is going to be thinking about how they look to store and dispose of those face coverings when employees in particular go into the workplace. So for example, if they've had to come in on public transport, even if they don't wear face covering when they're in the office, then you'll need to dispose of the one that wore on the journey in potentially. So it's very important then that you communicate to all employees about the new measures and processes you're going to put in place. And also I think you need to, at this stage, be thinking about perhaps putting in plan a contingency plan, if there's a further period of lockdown. And I think from the news last night that we could see that there's a real possibility. So if you can plan for that in advance, then great. Employees need to have worked through these points before allowing staff back into the workplace. So you also need to factor in perhaps a bit of time for communicating those to staff, factoring in training time if you need to train individuals, or if you want to have any sort of trial period or pilot periods where you practice opening up the office in advance of opening it up properly. So why are these steps so important, and what are the legal risks if you get those wrong? Well, you could face a claim from an employee or a third party, perhaps, for example, such as a visitor or a contractor, who claims that they have suffered injury as a result. And this might be a claim that they have contracted COVID-19, but it also could be a claim that they suffered some other kind of injury, such as a stress-related illness. And also, which we're going to discuss in a bit more detail later, the employee could potentially refuse to come to work. In practice, I think in reality, it's going to be really difficult for employees to prove that their employer is liable for them contracting COVID-19. And it's also worth noting that whilst prosecutions by the Health and Safety Executive and local authorities for breaching health and safety legislation are in reality quite rare, except in the most serious of cases, what we are expecting is that there is going to be an increase of spot checks by the Health and Safety Executive, particularly as employees now can contact them and notify them if they feel that their employer hasn't been complying with this health and safety regulations. So we certainly expect those spot checks to be on the rise, and obviously they would be without notice. You also need to try and avoid any potential discrimination in your return to work plans. So you need to check that your plans don't disadvantage certain protected groups of people. So for example, to make sure your arrangements for moving around the office don't disadvantage disabled employees, and any proposed changes to hours, for example, don't disadvantage women. If you do identify that there is any disadvantage, then you need to consider if there are any ways that you can work around that. But if you can't, and your proposed plans are proportionate, and there's no sort of less discriminatory way or alternatives to think about, then any discriminatory impact in those cases is likely to be justified. So I wanted to move on to discuss some potential problem areas. Oh, bear with me 1 second, I'm just trying to get on to the next slide. Yeah, great. Okay, so the next slide is about problem areas. So the first one I wanted to touch on is a situation where an employee refuses to come to work. And certainly that's something that I have seen is on the increase. The starting point is that employees must obey reasonable instructions. So if you ask them to come into work, they should be. However, there may be cases where it's not reasonable to instruct employees to return to work if the COVID secure guidelines that I've just mentioned have not been followed by the employer. In those circumstances, the employee could have the contractual right to reasonably refuse to come into work. However, in a situation where you've followed COVID secure guidance, but the employee is still refusing, an employee can refuse to work where they reasonably believe that there's a serious and imminent danger if they were to attend work. So in that sort of situation, they have the right not to have disciplinary action taken against them. They have the right for their pay not to be docked and for them not to be dismissed if they've acted because of that belief. And these types of claims have no cap on compensation. So obviously they are financially the higher value claims that we are seeing. Importantly, the test is an objective one as to whether or not there are circumstances of danger. And this is likely to be satisfied if the employer, as I say, is not complying with health and safety obligations. So there's no hand washing, no social distancing, but it's not automatic. But it's likely in those cases that that test will be met. Then the test for whether or not there's a serious and imminent threat, that's a subjective test. So it's the personal belief of the individual person in question. So the question is, was that employee's belief reasonable based on what they knew? And what they knew, or whether there was a serious and imminent danger. And that's why it's so important to discuss the arrangements and steps that you're going to be putting in place with staff, and because then you're putting that knowledge on them, and then it's less likely to be reasonable for them to fear that there is imminent danger in relation to their health and safety. And it's important to note also that that fear could relate to a danger that's in the workplace, but also it could relate, and I think in many cases it will relate to the journey or on their way into work rather than actually what their workplace, as it were. And certainly the surveys that I've seen have suggested that that is the case. So the bottom line is that you need to think before you deduct pay or dismiss an employee for not returning to work. You need to listen to the reasons that they're giving and respond to those if you don't agree, and explain why. And it might be appropriate to ask them what steps they feel could be taken to make them feel safer. And it will be for the employer to show what they have done in terms of taking necessary steps to make the employees aware of those. So what happens then if you're in a situation where an employee is not ill, they're not a vulnerable employee, they're not in a special category, and they're not concerned, or they're not citing any particular concerns about being in serious danger that we've just discussed, but they're just unwilling to come back to work? Well, in those types of cases, then you could potentially take disciplinary action against those employees where you're confident that you're taking all reasonably practicable steps to control those risks. But I would caution against doing this in most cases. Any dismissal could be regarded by the Employment Tribunal as unfair and potentially disproportionate in the current situation. And I really think tribunals will be sympathetic to employees on this point. And any disciplinary action, short of dismissal, could result in the employee resigning and trying to claim a constructive unfair dismissal. So the best approach currently is likely to be, if possible, to keep the employee on furlough leave if you can, or to put them on to unpaid leave. And certainly employees who are not able, ready and willing to attend to work, they don't have a right to remain paid. So in practice, that's also over time, that's likely to change. So as the furlough scheme is wound down and employees remain on unpaid leave at that point, then at that point you may decide as a business that it's unsustainable to keep those employees on. And in those circumstances, it may be appropriate to consider termination of employment. And certainly we're expecting as the situation develops and more employees return to work, it may also become safer for you to take disciplinary at that point. So I very much recommend that that's a situation that you play by ear. So the next area that I wanted just to touch on briefly was the employees' travel to work. So generally, the travelling to work is the employee's responsibility, but there is emerging case law that suggests that in some cases, employers can be responsible for their employees' journey into work. So you need to be careful and consider as part of your risk assessment, not only the risks that the employees face in the office, but also the risks that the employee may face by going into work. And in London, as I've mentioned, this is likely to be a particular concern to those employees that are going on public transport. And certainly I'm seeing clients arranging things such as taxis, additional parking at the office if you can get that luxury, cycle loans, all sorts of measures to try and ensure that there's a reduced risk of employees contracting the virus as they go into work. And certainly employers should be sympathetic to travel problems because it is likely to be a big concern to employees using public transport. So be fair and look for alternatives if you can. And interestingly, the research indicates that about 8% of employers at the moment are actually banning the use of public transport for their employees due to the concerns around health and safety in relation to that. So the third obstacle is childcare. And certainly I think the situation is easing slightly now that schools have reopened, but some employees are preferring still to keep their children at home and to keep them with them. It's a bit of a myth, or it is a myth, that employees have the right to paid leave if the school is closed or if their child is not fit to work. But it's important to talk through the reasons with the employee and give them their options. And in this situation where childcare is preventing the employee from coming back to work, the main options will be either for them to take holiday leave, or perhaps to go on unpaid dependent care leave, or they might be entitled to sick pay in some cases. Alternatively, keeping them on furlough leave, as I've already mentioned, might be an option here. So there are certainly good reasons, as I'm sure you all know, to be flexible and to accommodate the employees' needs, such as retention and goodwill, and certainly avoiding any potential claims of sex discrimination. Importantly, being a parent is not a protected characteristic, but in practice, more women than men are likely to undertake childcare. So indirect sex discrimination claims are possible in these types of situations. And this takes me to the fourth problem area, which is employees with particular issues who you have to treat slightly differently. And the first is pregnant employees. So if an employee is pregnant, they're treated slightly differently than other vulnerable people, and they may have a greater claim to being allowed to remain on home on full pay if they're not already on furlough leave themselves. So all pregnant women have been included in the list of clinically vulnerable people as a precaution, and they've been advised to be particularly careful about safe distancing. So as the employer, you have to assess the specific risks for pregnant employees, and where these are identified, you must do all you can to prevent or remove them. And it may be possible to do this by taking extra precautions to enforce safe distancing in the workplace. Importantly, the current guidance doesn't say that vulnerable employees can never be asked to work, and this includes pregnant employees. But it's a matter for your own risk assessment and whether you're confident that you can provide a safe place of work for them. If you can't ensure safe working conditions, then you need to temporarily consider altering the employee's working conditions, perhaps providing them with another suitable alternative role on the same terms and conditions, or perhaps as a last resort, consider suspending the employee, but that will be on full pay. And that right to suspend on full pay does not apply to other vulnerable employees. So pregnant employees are in this sort of protected category. So what about vulnerable employees? Well, the government recognises two groups of vulnerable people: those who are clinically extremely vulnerable, who've been advised to shield themselves, and those who are clinically vulnerable. And the government guidance says that clinically extremely vulnerable people are strongly advised not to work outside the home, so they should not return to work. And the latest guidance on safe travel underlines this by advising clinically vulnerable people not to travel. So if they cannot work from home, they would be entitled to statutory sick pay, or if you can, then they could stay on furlough leave if that's an option for you. So clinically vulnerable people who cannot work from home can return to work, but they must take extra care with social distancing. And in line with the government's guidance, they should be offered the option of the safest role possible within the workplace, which might be available on site. And that will enable them hopefully to stay within the requisite 2 meters of other people. If in practice there's no such role available, then the guidance suggests assessing whether there's an acceptable level of risk. And I think in this case, I'd consider that remaining on probably furlough leave, or again, taking unpaid leave, is currently a better approach than that for vulnerable employees if they're unhappy about returning to work, given the associated legal risks that we've identified. It's worth noting that many vulnerable employees will also classify as being legally disabled. So this means they have the right to have reasonable adjustments. And this could potentially include staying at home, but we don't think that that would extend to staying at home whilst being on full pay. It's also unlawful to operate provisions, criteria or practices which would put disabled employees at a disadvantage compared with non-disabled employees, unless that is justified. So, for example, a policy of requiring vulnerable people to return to work could potentially be indirectly discriminatory and require justification. But it may be hard to justify requiring an unwilling vulnerable employee to come back to work, for example, if other employees could cover their work or you could get a temporary replacement for them. And in my view, you're not required to pay a vulnerable employee who's not willing to return to work unless they have a reasonable belief that they are in serious and imminent danger, as we've discussed briefly already. And finally, there is some emerging evidence that BAME employees may be at a higher risk of COVID-19, and this raises issues of possible indirect discrimination. And the same potentially could apply to older men as well. The situation at present is unclear. I think there's lots of research going on into this area, so it's possible that government guidance will be produced. And I did notice last night that further government guidance for frontline workers, key workers, has been introduced for BAME employees. As of yet, I'm not aware that that's been extended, but that's certainly something to be aware of going forward. So next, apologies if you can hear the background noise. I've got a Velox window above me and it's heavily raining, so hopefully you can all still hear me okay. The next thing I wanted to talk about was medical testing and monitoring, because that's something that our clients have been asking quite a lot about over the last couple of weeks. You need to be quite cautious about introducing mandatory temperature readings for all staff, because there's quite a few contractual and data protection hurdles that you need to overcome to be able to do that safely. But many of our clients have introduced a voluntary scheme of testing. So when employees enter the building, they have their temperature taken. And from what I've been made aware, that's all been received or gratefully received by employees. And that hasn't really been any pushback as far as I can see, or I've been told. And the government workplace safety guidance doesn't include temperature checking or medical testing in the list of steps that employees should necessarily be taking. However, reflecting the reality that lots of employers are, the Information Commissioner's Office has introduced some quite useful guidance about data protection issues to be aware of in that type of situation. So if you are going to be taking temperature readings, or if you're going to be asking employees to be taking medical tests, there are a number of things that can be done to mitigate these data protection risks. And these include being completely transparent with your workers as to what use will be made of that data, not retaining that data for any time period longer than is needed. So for example, if you're testing the temperature on access to the building, then you can delete it instantly, unless you might want to keep it, for example, because you have to prevent entry into the building for a particular employee. in which case, that needs to be noted and recorded. Anything that's stored, you need to use for no other purpose and restrict the access to as few people as possible with legitimate reasons for them to have access to that information. And then you need to undertake a data protection impact assessment, setting out clearly why any measures in your view are necessary for the specific workplace that you're in. And then when it comes to testing anyone with COVID-19, so under the NHS system now, anyone who has COVID-19 symptoms can ask for a test to see if they have the virus. And certainly employers can encourage employees to take the test now that they are available. But there are data protection risks if you're going to then insist that the employees take the test and then reveal the results. And in practice, we've found that given the time it's taking for the results to be published, there's likely to be little justification to require employees to take quite an invasive test. But it may be possible. It may be possible in some cases if you need to, just be aware of potential data protection issues. But again, in reality, I think my experience is that employees generally have been quite open to testing and willing to share the results of that. So hopefully you won't hit too many hurdles when it comes to that if you do decide that that's a step that you want to take. And finally, I just wanted to briefly go through my top tips for you just to take away with you today. Sort of discussed the risk assessments are really going to be key when it comes to justifying any action you've taken, or equally any action that you have decided not to take. And it's really important for you to, if you can, to try and drill down into the detail as much as possible and to document your decision making as you go through that process. So even if something doesn't end up in your policy at the end or the risk assessment at the end, you need to document why you've made those decisions and why you've come to those conclusions. Second point is that it's really important to demonstrate compliance with the government guidance. So my experience over the last couple of weeks is that those businesses that are now facing challenges are not necessarily ones that haven't put in place the measures. They've done everything that they should be doing, but what they haven't done is gone that step further and ensured that employees are complying with the policies that have been put in place. And it's a bit of a mindset issue, but you can have all the measurements and steps taken that you would want to take in place, but if employees are going to disregard them, and specifically the social distancing when they're in the office, it's going to be really important for employers to take action quickly to stop those behaviours before they're allowed to set in and before disgruntled employees start to complain. And in cases where the rules are being disregarded, then it might be appropriate to discipline individuals who have behaved irresponsibly. Then you might consider perhaps wanting to help you with that, to set up some sort of system in place for employees to flag concerns with you if they have concerns that health and safety measures are not working or being observed in the workplace. And you'll probably have something similar that could be used, like a whistleblowing policy, but you might want to introduce something specific for this situation. Number 3 is engaging with employees, as I've mentioned. And again, this is from what I've seen over the last few weeks. Those employees that have been really successful in opening up or are opening wider than they currently are those employees that have really engaged with staff about the measures that they're proposing to put in place. They've given them lots of time to digest that information and opportunity to input into those policies and practices where possible. So, by way of surveys and that sort of thing. Those businesses have really done well and really have hit the ground running. The fourth point I wanted to mention is that you address individual concerns and try and find a solution. So it's really important before making any decisions to try and find out why the individual has concerns, because in lots of cases it might not be immediately apparent or obvious why they have those concerns. And there may be a workaround that is possible. And if a workaround isn't possible, then at least the employee will feel that they have been listened to and their concerns have been understood. And sometimes I find that can go a long way. Point 5 is that you need to document any changes, agreed changes to working hours or patterns, so there can be no misunderstandings or disputes further down the line. And also point 6 is don't forget that the furlough scheme may be the best solution to employees who can't work. It's not just for situations where the employees are not required to work. It may be appropriate where they can't, for example, if their journey into work poses too much of a risk for them, or they have childcare issues, which is causing problems for them. But importantly, the deadline, obviously, if you haven't used the furlough scheme before the 10th of June, then you won't be able to use a new furlough scheme that's been introduced from the 1st of July onwards. Then you need to think carefully about taking any action against an employee. And at the moment, it's really, from an employment law perspective, it's really uncharted territory that we're dealing with. And we certainly are expecting there to be a big increase in employment tribunal claims as a result. So I'd certainly recommend that you only take action against an employee where you're 100% confident that it's justified. And the last point is maintaining support for employees' well-being and being aware of the need to protect their mental health as well as their physical safety, particularly when they're working from home. And it's interesting to note that a survey that I read recently said that around a quarter of employers in the UK have said that they've seen a significant increase in mental health problems from employees working from home. And it certainly does beg the question, in my view, whether or not the effort to maintain productivity is coming at a cost to employee well-being. And I question what sort of problems we might be storing up or saving up for the future that we're going to have to deal with. So that's all from me. I hope you found that useful. I'm very happy to take questions, as Hannah said, at the end after Adam has spoken, but I'm going to now pass over to Adam, who's going to take a look at the landlord and tenant issues on a return to work.
Hi, thank you, Rona. Good morning, everybody. Thank you for joining us. I'm just going to bring up my slides onto the screen so that just a moment while that loads. Yeah, I think, Rona, if you can just take your, that's it, perfect, thank you. Okay, morning. Right, thank you all for joining us. As I say, this section of the talk is going to focus on the issues for landlords and tenants as we begin to return to what's been coined as the new normal in terms of the landlord and tenant relationship. And what I wanted to begin by doing is just to think about, as you see from the title of the first slide there, is to think about who is realistically going to be doing what to which particular sections of the building. And that is ultimately going to depend, of course, upon which type of lease is in place and the various rights and responsibilities under it. And so with that in mind, what I've tried to do here, emphasis on try, because it's very hard to sort of put leases into sort of specific buckets, if you like, but I've tried to look at the different types of categories most common for commercial leases. And the first type, I would say, are leases of part. And with this, I have in mind office premises or perhaps retail units within shopping centres, essentially places where the tenant has the exclusive use of a particular section of the building, but nonetheless the other remaining sections are controlled by the landlord, and the tenant has rights within the lease to use those common areas. And again, the obvious example, take a large London skyscraper building where you'd have a common access lobby and then common access to lifts and stairwells and so on, so that the tenants can reach their own individual sections. And the second type of lease, by contrast, as I've called in the slide there, is a lease of the whole. And this will differ, broadly speaking, in terms of the size of the demise, the premises which the tenant has exclusive use of. And so here we could be talking about standalone shop premises, for example, that you may find on the high street. It could also include premises such as restaurants, bars, hotels, cinemas perhaps, also more general commercial units, factories, warehouses, production facilities, and so on. And so those leases, in those cases, the tenant has far more control over the space which it's using. Going back then to the category A lease and thinking about the type of COVID works which might need to be carried out and who's going to do them. As I say, the landlord in those cases is going to be responsible for repairs and maintenance to the common parts of the building. So you would expect, I would think, to find measures such as perspex screening, partitioning in the lobby areas, sanitizer stations being installed, perhaps lift entrances and exits, one-way systems on the stairwells and so on. Again, by contrast, in a category B lease, those where the tenant has the entirety of the premises to itself, of course, it's going to then be responsible for taking all of those measures itself as well. For example, if it's, as I say, a standalone retail unit, then from the moment a customer walks through the door, it's going to be the tenant's responsibility to make sure that all of the COVID secure measures are in place. So this will probably lead on to the next section, and probably one of the most important things to bear in mind, particularly from a tenant point of view, if it's going to be the tenant making the COVID secure alterations, and I think in most cases it probably will be. And so the first point really to consider with this is what is required in terms of landlord consent. And this, I have to say, is unfortunately quite a heavily litigated area, so it is worth taking paying additional care to what the lease says about the extent of freedom that the tenant has to carry out the work that it wants to do. And the covenants which control, that's the obligations of the tenant in this respect, can vary. Sometimes in, I would say, older leases, you can find situations where there's an absolute covenant against making any alterations whatsoever. That's actually quite rare these days because it's quite impractical for the landlord to want to be involved in every little alteration that the tenant wants to make. But nonetheless, you can find, as I say, some older leases which do impose, as I say, an absolute restriction on making alterations. And in those cases, the tenant really would have no choice but to approach the landlord straight off and say, and this is what I want to do. The lease doesn't permit it, but given the circumstances, surely it's a good idea. As most leases, though, aren't that restrictive or prohibitive. They usually have a provision which is that alterations can be permitted with the consent of the landlord. And the quid pro quo on that, if you like, is that there is usually the suffix that the landlord's consent can't be unreasonably withheld. And even if actually the lease doesn't say that in writing, the tenant has the benefit of a statute which will imply that same qualification. So when dealing with applications for consent to alterations, in most cases, the landlord will be under an obligation to act reasonably. And I would think that in the specific context of COVID works, it would be, I think, quite unusual, perhaps unwise, for a landlord to take or to reject out of hand at least any application made by the tenant to carry out alterations to its premises, which are going to be obviously for the benefit of everyone, and in particular, as Rona's been touching on, the employees who will be coming and going from that building. Moving on to the next point I wanted to talk about on landlord consent. Having just said that the landlord is under an obligation to act reasonably in most cases, there are a couple of notable caveats, traps for tenants, if you like, risk areas, which I wanted to mention. And the first of those concerns what is commonly coined as retrospective consent to alterations. Now, in those cases, this is, take for example, a tenant may think, well, actually, we've got a short space of time to get our premises ready to reopen, to continue the business in terms of the government sort of timetable. Minor alterations are required. Unclear from the lease whether actually landlord consent is required. We may as well just get on and do it, and then present the case to the landlord afterward and say, look, we've had to do this, and it didn't really, and I'm sure you understand why it was necessary, etc., etc. Again, you would like to think the landlord in that situation would say, well, yes, of course, fair enough. Tell me what you've done, give me the details. I may send a surveyor in to have a look, but that will be the end of that. But the risk is that if you are approaching your landlord on that basis, you're not going to them and saying, I want to exercise a right under the lease to carry out alterations, permitted alterations. what's actually happening is the tenant is presenting the landlord with a breach of the lease and saying, well, I want you to sign off on this nonetheless. And of course, that changes things because the landlord is then not going to be under an obligation necessarily to accept the breach, the same as any breach of contract. You wouldn't really expect the innocent party to be told, well, you have to accept this, and if not, I'm going to potentially take you to court and say you're being unreasonable. So in that situation, the tenant is far more likely to find themselves at the landlord's discretion than they would perhaps like. So that's something to bear in mind. And the other topic under this heading I wanted to mention was something called the extent of the demise. And that is a bit of an odd phrase. It sounds perhaps more like the title to a melancholy poem than a piece of legal terminology, but it is no less effective for that. What I'm talking about when I say the extent of the demise is the extent of the physical space which the tenant is allowed to occupy under the terms of its lease. And this could be, take the example that's often used of an eggshell. In the inside of that eggshell, a very thin membrane, and that's a similar concept in some leases, particularly office leases, for example, where the demise space really extends no more than perhaps a few inches into the ceiling space, into the floor, etc., and certainly into the walls as well. And so this can create an issue if the tenant wants to carry out alterations. Say, for example, there's a stud wall, a partition wall, which not structural. The lease doesn't say anything about it. Consent being required for non-structural alterations. That's quite common. The tenant may decide, well, actually, in that case, in order to make a two-way passageway to comply with the regulations, I'm going to take out a section of that wall. Again, if that were to happen, the landlord were to object, it would be in a very strong position because essentially what a tenant is doing, if it carries out alterations which go beyond the extent of what they've been granted under the terms of the lease, it's a trespass onto the landlord's retained parts of the property. And I remember just a few years ago, I had a case where we actually got to the point of having to take out an injunction. We were acting for the landlord at that time against the tenant who refused to accept the premise that they could not carry out works beyond the demise of the lease. And so it's quite an important point to bear in mind if, for example, the alterations in question involve drilling perhaps into the floors or ceilings, or, as I say, the example of perhaps taking out a stud or partition wall, seemingly insignificant, but nevertheless, it may prove to be problematic. Moving on to our next slide then, I want to talk about the reinstatement of these alterations. And of course, at the moment, we are still dealing with this awful pandemic, and the alterations which are going to be necessary to buildings are being carried out as a matter of course, I expect, or at least they probably will be. In a few years' time, though, they may be less important, and I suppose there is a risk then that these alterations may essentially be forgotten about and not really thought about until the end of the lease, where of course we begin to enter into the realm of reinstatement of alterations and dilapidation claims, and that's another sort of quite heavily litigated area. And so the starting point in most leases is going to be that the landlord is entitled to take the premises back in exactly the condition that they were granted, excuse me, to the tenant at the beginning of the term. And so if alterations have been carried out, which the tenant would prefer not to have to be reinstated at the end of the lease, then it's going to be advisable to document that agreement with the landlord at the time, i.e. at the moment now, so that there's no scope for argument later on, and the dilapidation surveyor instructed by the landlord will cost up the potential expense of the landlord in reinstating the alterations otherwise. And as I say that, it would be sensible to document any agreement that you do reach with landlord at this time to avoid that kind of future argument. The other point I wanted to mention when it comes to once alterations are in place, reinstatement, taking them out and so on, is break clauses. And this again could be quite a risk area for tenants if in say a year or two's time there's a break right in the lease and want to bring it to an end early. The break notice is served, no problem with that, it's effective, but the break right itself in the lease contains a condition that the tenant must return vacant possession of the premises to the landlord in order for the break clause to be effective. And that is not an uncommon condition in many leases. And the relevance, I think, of this point is that we have a few years ago, and the decision still stands, a finding from the High Court that a tenant who left behind demountable partitioning at the end of what would have been the term of the lease if the break right had been effective was found not to have returned vacant possession because of the fact of that partitioning had been left in place. And say it wasn't a permanent thing, but nevertheless, it was something I think the tenant could have removed. And so therefore, the court felt that the vacant possession had not been returned. And so the break right in that particular case had not been effective. And to say that's probably quite a rare scenario, but potentially quite a costly one. It's particularly so if you consider that at the moment, passing rents under most leases, even those I suppose a year or two old, are probably quite a way above the ERV, the estimated rental value of premises which you would take if you were to be entering into a new lease. And in fact, I think a lot of new leases actually are being entered into a zero rents or turnover rents at the moment. So again, it's a potential problem area which is worth looking at in a bit more detail if necessary. The next point that I wanted to cover was the effect of the service charge on the works which the landlord potentially is responsible for carrying out to the common parts of a building. If we just go back at the beginning of the talk, I mentioned the first category of leases, those in which the common areas may need to be modified in order to make them COVID secure, and the landlord is going to want to, or should, carry out those works. But it will, I suspect, in some cases, landlords will want to look to recover the cost of doing those works through the service charge. I say this may not happen in every case, but it could in some. And that, I think, will cause close consideration to be given to the terms of the heads of cost, I should say, which the landlord can recover under the terms of the service charge. Because, of course, the primary purpose of the service charge is to allow the landlord to recoup the costs it incurs in maintaining the building, putting it in a good state of repair and maintaining it. But usually the tenant will object at the grant of the lease to the service charge revisions being drafted too widely. This is usual sort of a battle between the landlord and tenant solicitors at this stage in order to make sure that the service charge isn't too wide and doesn't catch the tenant with liability for improvements to the building the landlord might want to carry out. Of course, when these grant clauses were drafted, no one had in mind a global pandemic such as COVID-19, and that alterations may actually be needed in order to deal with that. So the wording of many of those leases, as they are, I suspect, will probably put, well, COVID alterations, are they improvements or are they necessary repairs? And you can see how the argument could go either way on that. Is it a repair or maintenance? Perhaps not, because you could have a brand new building in pristine condition, not needing a touch of repair, but nevertheless needing to be quite heavily modified in order to make it COVID secure, improved. So again, that could be a potential flashpoint in that respect. Turning then just to some closing remarks from me. I've just had a look back, as I say, over the past few minutes on potential flashpoints which could crop up between landlord and tenants. And I think probably the key message, key headline from me, speaking as a property litigation lawyer, is that the key to avoiding these type of disputes and minimising the cost of them, particularly, is really to communicate and to collaborate and really take a constructive approach with your opposite number, and this applies equally, whether you're a landlord or a tenant. We've heard the term mentioned so many times, but it is unprecedented. And as I say earlier, the leases are just not drafted to take account in many cases of this type of situation. And I think it really requires some give and take between landlord and tenants to actually pull together and put in place a system of protocols that make sure that the building, the premises are safe for employees, for visitors, etc. And to document everything that's agreed along those lines in writing. And that should, as I say, hopefully avoid some of the potential pitfalls later down the line, as I was mentioning, in terms of, say, dilapidations, reinstatement of alterations on break clauses and things like that. Okay, I think that is pretty much all I had to say in so far as the presentation goes. I think, as I said, we are going to be taking some questions. So I will pass back to Hannah at this point.
Thank you so much, Adam, and thank you, Rona, as well. It was super interesting. So Salim, who's a partner at Cripps, is now back on. Hi, Salim, who's joining us, and Salim's just going to be moderating the Q&A part of the session now. So some of you have already been doing so. Please do feel completely free to just write in with any questions that you have that can be added by Adam or Rona or Salim himself. Thanks very much.
Thank you, Hannah. Yeah, we've got some questions to put to Rona and Adam, but first of all, I think probably to help provide even more context to what they've been talking about, to get a feel for what's actually going on out there, because it's obviously a very fluid situation. I thought it'd be quite helpful just to quickly hear from each of Rona and Adam to give us just a little snapshot of what's currently on their desk. You know, what are they actually advising clients on and talking to them about? So over to you.
Yeah, I think, thanks, Salim. From my point of view, what's on my desk at the moment is, unsurprisingly, I get a lot of redundancy advice. And certainly what I'm seeing is employers, some have already taken the step of making redundancies, but a lot are preparing for that and envisaging the end of the furlough scheme at the end of October as being the sort of the trigger point to press ahead with those if they need to. And lots of employees are looking to, employers are looking to try and utilise the furlough scheme if they can, to cover off some of the employees' notice period to minimise the financial implication of those redundancies. So yeah, a lot of advice around that. And for our retail clients in particular, at the moment, it's a really busy time, obviously having just opened up non-essential retail at the beginning of the week. We've had lots of questions, you know, about how to support employees, exactly what we've discussed today, what measures we need to be putting in place and that sort of thing. But certainly we are expecting, as I mentioned earlier, that the level of tribunal claims arising out of COVID-19 and the current situation is going to be on the increase. So we are preparing ourselves for an influx, unfortunately, for a number of employers, of litigation arising as a result of this.
Thank you. Adam.
Thanks, Rona. Yeah, I think on my desk at the moment, I think as you probably expect, a lot of the work is focused on landlord and tenant, and the financial pressures actually that the lockdown period has placed on both sides. So we're dealing with lots of requests for drafting rent concession agreements, also advising on whether or not it's possible for tenants to suspend rents if landlords have taken out insurance against a potential outbreak of notifiable diseases. That's a sort of interesting topic that's going on at the moment. We've also, again, some tenants asking, have the leases been frustrated in terms of their requirement to pay the rent again? And so that's taking up, I think, quite a lot of the work that we're doing at the moment. And also the other side of it, unfortunately, is going to be relating to tenant-related insolvencies. And we're seeing, I think, quite a few administrations, CVAs, liquidations, things like that. And I suspect, unfortunately, there may be some more of those to come. But again, it's advising around those issues as well.
Thank you. We've had a question in, someone sort of saying they're 65 of age at present, working from home. You know, when do you envisage vulnerable people going back to the workplace? And I sort of was having a little think about that question. And because I know that the government guidance changed recently at the beginning of June, and it was saying that you know, people who who are shielding can leave the house now, but only if they maintain strict social distancing, and that guidance still refers to the 2-metre rule. I think if we're putting sort of shielding and vulnerable people to one side, I mean, obviously Rona and Adam have talked about the practicalities of being able to go back to work and what that means, in relation to the employer-employee relationship. But I think the difficulty we've got at the moment is that things are just changing, and quite quickly, quite fluidly. I'm a governor of a school where I live, and actually sometimes guidance is being released that's applicable to us, and within 10 minutes of it coming out, we're getting an email from a parent saying, what are you going to do about it? We haven't even been told that something's changed. So actually, I think where we are at the moment is that things are, very fluid. And when you're talking to people, the sense I get is that people are trying to work towards a situation where we think that we're going to be going back to work, from September in some shape or form, but not as we previously knew it. But actually some people are taking the view, and I guess mindful of also commuting, public transport and things like that, they're saying, look, I don't even want to think about this until the new year, because at the moment the guidance says if you can work from home, you should work from home. And I think, obviously all of this guidance that's there, you take a step back as well, and then you've got this further layer of protection that needs to be afforded to people who are vulnerable and people who are shielding for different reasons. So I don't think we really know how things are going to go, and that's of course assuming that we don't have to take a step back and actually row back from some of the relaxations that are there at the moment. So, as to how that's going to work, I don't think we know. I mean, we hope that things will reduce, and that the virus in the community will reduce, and we can open up further and further until we start feeling like life is becoming more normal again. But in all truth, we just don't know. There's a question there for you, Adam, I think, in terms of does a serviced office provider need to share their risk assessment with someone who has a suite?
I think it goes really down to that point of collaborating. I mean, I think in terms of risk assessments, yes, you would want to know, and I suppose it will span onto the sort of the employee question as well. But certainly, I think that if you are even in a serviced office environment, you then have an even smaller section of the building I was talking about earlier. But you would want to know that who's ever in control of the other sections of it has taken, the appropriate steps in to do that. So certainly, I think it's something that you would be entitled to request and to look at, and also to speak if you've got any concerns about the remainder of the building, which is not in your control, if you like, to have a conversation about that.
Thank you. One for you, Rona. In terms of, obviously you were talking about the data protection pieces that you just need to be slightly aware of when we're talking about people's health and employees in the workplace. But does an employee have a right to be notified if a colleague has suspected or diagnosed COVID-19?
No, they don't have a specific right, but it's quite a difficult situation, this one, to deal with, because you obviously owe the colleague a duty of confidentiality, and there's privacy obligations in relation to that employee. But for the other employees, you also owe them a duty of care and a duty to protect their health and safety. So that's a really tricky situation. I think to try and balance those obligations, I think you could possibly notify employees if they have been in contact with someone who has symptoms of COVID-19 or has COVID-19, but without disclosing who that is. And where that isn't possible, so if it's obvious who it is, then I'd say you just have to limit it to as fewer people as possible. But I think from my experience, I think employees generally have been very keen to share this information. And I would hope there's a situation where in practice, when it comes to it, you wouldn't have too much pushback, but you obviously would need to check with the employee, that they're happy for you to disclose, their details or their names specifically. And if you don't have that consent, then as I say, you need to try and do it as anonymously as possible and limit it into numbers.
Thank you. We sort of had a question in, I'm not sure if it's fair to ask either of you, because I'm not sure if it falls specifically into your remit, but I'd rather ask you than me try and answer it. But I mean, in terms of risk assessing visitors to premises and offices, is there a particular way of dealing with that? I mean, is it that basically, the person who occupies the premises just needs to take a step back and, as part of their overall risk assessment, sit down and say, well, this is how we're intending on using our premises during this particular period, who could be coming to the premises, and therefore we just need to consider that. I mean, I know certainly from our perspective, we're starting to consider about going back to the office, but at the moment, in those initial stages, we're certainly not opening up our meeting rooms, so because we can actually deal with those things remotely anyway, and so it's not deemed to be absolutely necessary. So I think from our perspective, we've just decided visitors, unless they're absolutely essential, shouldn't be coming in. So therefore that's reduced, I suppose, quite an element of risk when it comes to spreading and the social distancing. But I'm just wondering, I suppose maybe you, Adam, have you had any conversations with people around that?
No, I mean, it's an interesting point. This, I think, it's going to constantly pick up. We talk about, particularly if we're talking about leasehold premises, the tenant has a right to exclusive possession of those spaces, and so by definition, they're going to be able to set the criteria for people coming and going. The saying is often that you have the right to exclude the world at large from your leased premises if you want to. So there is that margin of appreciation there, and I think, again, it is going to come down to individual interpretation of the rules and reaching, I suppose, like you say, a tolerance of what is acceptable for the particular business that you've got. You may have more of a customer-facing business, say, than we might ordinarily have as an office of solicitors. So, but certainly, I think it is in terms of property law, at least, there is definitely sort of the right for a tenant to say who comes and who goes.
I think I'd mention that I'd look on the Health and Safety Executive website. They have quite a few sort of template guidance documents around health and safety risk assessments for, service users, employees and consultants and that sort of thing. So that probably would be my starting point. And then the CBI have also quite a lot of guidance about undertaking risk assessments. So those might be two places you could look to find that information and support with that.
Thank you, Raina. Thank you, Adam. I've got one more question, unless anyone else is going to raise any, which is, you hear people talking about this in terms of just the interaction of people being on furlough with a redundancy consultation process, and sort of people seem to say differing things. I suppose a simple question, I hope, is, can you do a redundancy consultation with someone while someone is on furlough?
Yes, yes, is the short answer. You absolutely can. At the early stages, it was a bit of a grey area, and in particular, when it comes to collective consultation, where you have over 20 employees, and you need to be electing reps and consulting with them, there was a bit of a question around whether or not being a representative and consulting with them as part of a redundancy process would amount to work, and therefore would it be in breach of the furlough scheme. But the government guidance that's subsequently been issued has absolutely confirmed that no, that's fine. You can consult with staff, and that won't be deemed to be work, and therefore won't invalidate the furlough leave. Great,
thank you. And I think that's probably it for the questions, unless anyone's got anything to raise. But I mean, if not, then over to you, Hannah.
Brilliant. Well, thank you so much to the three of you. That was it was really, really interesting and pertinent, of course, everything that you've covered today. I'd like to let everyone know who's joined us that I'll be sending out an email with a feedback survey later, which will be really useful if you could fill in. And in that, I will also be including the contact details for Adam, Rona and Salim. So if you would like to follow up, learn more about CRIPS, or if you have any more questions, you can contact them via there. I will also be including the presentations that you've seen in this morning's webinar, if you'd like to refer to them. And I will also be including the link to watch this webinar on YouTube where it's been streamed. So if you think it would be of interest to a colleague or contact of yours, then please do share it with them. But yeah, and also do keep an eye on the Spanish Chamber's regular email communication on our website, because we have a lot of other online events coming up over the coming weeks. But thank you again, Adam, Rona and Salim, for your collaboration with us this morning. And yeah, all the very best.
Thank you.
Thank you.